Hello everybody, it's Walter, your favorite historian, educator, professor, and social studies extraordinaire, here today to discuss with you how Alabama continues to violate the Voting Rights Act of 1965 with its congressional redistricting schemes. So on the 5th of September 2023, a three-judge U.S. District Court panel struck down a proposed congressional redistricting plan from the state of Alabama. Why did they do that? Well, the state of Alabama failed to create a second majority black congressional district as it had been ordered to do so by the Supreme Court of the United States in June of 2023. The court ordered the state to create a second black majority district, or quote unquote something close to it. All right? Alabama did not do this. And the unanimous decision from the three-judge U.S. District Court panel wrote that they were deeply disturbed by the state's actions. The panel itself, all right, reflects the visceral nature of the subject at hand here, because two of the members of this panel were appointed by President Donald Trump. So you can't say that this is a partisan thing, folks. This is about enforcing the law and the Constitution. So in June of 2023, the Supreme Court of the United States, by a surprising 5-4 decision, ordered that the state's congressional districting maps be redrawn to comply with the standards set forth in the Voting Rights Act of 1965 and give greater electoral balance to the black voters in the state of Alabama. Now, black folks represent and make up 27% of the population in the state of Alabama, but only one of the state's congressional districts is majority black. All the rest are majority white. Interestingly, but not surprisingly, Alabama intentionally did not comply with the Supreme Court's decision in June and admitted to not doing so. That's Alabama for you. Alabama has stated that they will appeal the decision of the three-judge panel back to the Supreme Court itself. All right? Good luck with that one. So the Republican-led legislature drew a map that was signed into law by the governor, and it intentionally attempted to bypass the court's decision by continuing to maintain one black majority district in the state and only boosting the black population in another district to only 30 or 40% of that district's population. All right, that is not in compliance with the Supreme Court's order in any way, shape, or form, no matter how you cut the cake. That's Alabama for you, always attempting to defy the law and the Constitution. All right, I don't know what these guys are on down there, but I tell you, Alabama has a long history of defying the federal courts, to deny African Americans their appropriate electoral power, just like most of the South. Okay. And the basis behind the Supreme Court's order was to force Alabama to create a second district that affords the state's black voters, like everybody else, a fair and reasonable opportunity to elect candidates of their choice. And obviously, that map failed to do so. All right. The district court thus ordered a special master to submit 3 proposed maps that would create a second black majority district in the state by September 25th of 2023. Alabama's defense in not complying with the Supreme Court's decision, which failed to convince the district court, held that it was aimed at maintaining traditional guidelines for congressional redistricting, such as keeping communities of interest together. All right. Another basis of their defense was the concurring opinion of Justice Brett Kavanaugh in the June decision from the Supreme Court, which questioned whether or not race-based redistricting can extend indefinitely into the future. Well, it seems like as long as states continue to deliberately weaken minority voting power, then obviously it's a question that can be extended into the future for as long as it needs to be. Stop discriminating on the basis of people's race, and you won't have this problem, Alabama, but you can't seem to catch on and do that. So yes, this is necessary, okay? And the district court wasn't buying it, holding that, if the Supreme Court really did feel that way, they wouldn't have affirmed the injunction back in June, all right? So the district court also rejected arguments by the state of Alabama that it would result in quote-unquote affirmative action in redistricting, which is total BS. Holding that the Voting Rights Act only guarantees equality of opportunity, which is exactly correct. It does not guarantee success for a minority preferred candidate. So the Voting Rights Act doesn't give black voters a leg up, ladies and gentlemen. It merely prevents black voters and other minority voters from being kept down with regard to what is arguably the most fundamental, political right. And that is the preservative of all rights, the right to vote. Okay. Now, anybody with, a half a milligram of political intellect can see that Alabama's decision to not comply with the Supreme Court's ruling in June is merely another unfortunate chapter in its history of attempting to maintain a system where blacks are second class and absolutely irrelevant to the political direction of the state, to put it very mildly. Alabama, like many states in the Deep South, has a long history of discriminatory practices against African Americans in keeping them as politically impotent as possible, thus not being able to affect the political direction of the state and not being able to influence the outcomes of legislative and otherwise decisions. Anybody can see that Alabama's decision was not about keeping quote unquote communities together. Wrong. It was about keeping the Republican Party in power. And of course, you are creating a second black majority district. That means, guess what? A Democrat will be elected, which obviously promotes a challenge to the Republican agenda. Anybody can see this, folks. This is as plain as day. And people today sadly still argue that we don't need laws anymore like the Civil Rights Act of 1964 or the Voting Rights Act of 1965, which is bunk. Alabama provides a clear example of just why you need those laws, because the legislatures in these states have a clear agenda of keeping black people as politically powerless as possible. As the old saying goes, the more things change, the more they stay the same. If Alabama was truly interested in complying with the Voting Rights Act of 1965 and the 14th Amendment to the Constitution, which among other things requires equal protection of the laws, then it would not bend over backwards and break its neck to continue to dilute the power of black voters in the state. I could go on for hours about this, but I think I pretty much said it all. Alabama, along with the rest of the South, continues to act the way they did in the 1950s and 60s, all right? And all I can say is thank goodness that you have the federal courts to check that power, all right? So I conclude by saying stay focused and stay alert, because the most important right you have, folks, is the right to vote. Do not let states take that away from you. So I conclude in wishing you all well. Take care of yourself. Stay safe out there. And remember, believe in yourself. Dream, try, and do good. Professor Shelton, out.